Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Well, Jeff Roberts, welcome back. Let's jump into construction accidents today. This is a little bit more than just home building accidents. Why don't we talk about that? And you've got obviously a big part of your practice deals with these types of injuries, and sometimes they actually jump right over or trip right over, if you will, into workers' comp. So why don't we unpack that today?
Yes, I've represented a lot of people in the construction trades during my career, union workers and non-union workers. From that standpoint, you have, as you mentioned, home builders, but also the commercial industry, bridge builders, road builders, things of that nature, are all involved in the construction industry. And that can be a very dangerous injury. A lot of times the injuries that occur in those settings can be very, very serious injuries. You can have minor injuries there as well, where somebody strains a muscle without it being something real significant. But a lot of times you will have significant injuries from that type of a field, and those are different than a factory injury or that type of an employment injury. If you're, if a construction worker is injured while they're at work, then there's going to be a workers' compensation claim involved for that individual. But also in those type of settings, you see a combination of a workers' compensation claim and also a potential negligence claim if the injury is caused by someone besides a co-worker, or if it's caused by another subcontractor's employee causing the injury, or in the road construction field, a driver on the highway who ignores the warning signs and strikes someone or something of that nature.
And that's what you usually refer to as a third-party claim, correct?
Correct. In the legal field, we refer to that as a third-party negligence action or a third-party claim. It's a claim against the negligent party, and you have that claim in addition to the workers' compensation claim, and they have some interaction and some overlay that has to be dealt with from that standpoint. So they are a little different than just a normal car wreck case that doesn't have any kind of a workers' comp component to it, and different than a standard workers' compensation claim that doesn't have a negligence component to it.
And would you file those at the same time? I mean, do they run concurrently, or does one come first and then the other one follows, in terms of if I had a workers' comp claim and a third-party claim?
As far as filing the formal complaint to get the matter in front of a judge, that would occur at different times as a general rule. But pursuing the claims themselves would run concurrently. Dealing with the workers' comp insurance company and dealing with the third-party insurance company all occurs at the same time. When we get medical records in, making sure the bills are paid, making sure lost wages are paid, taking care of all of that kind of occurs even before you file the formal complaint or claim forms to get it in front of a judge.
And then again, the good thing about working down here with the Roberts Law Office is you can handle both sides of that.
Exactly. There's a lot of law firms that will handle a negligence claim, but they don't handle workers' compensation claims, and vice versa. There are firms that handle workers' compensation claims, but they don't handle negligence claims. And that's fine. I understand that some attorneys are more comfortable in doing certain types of claims and not doing other types of claims. And I've got friends that will handle negligence claims that don't handle workers' compensation claims from all over the state, actually. And if they have a negligence claim that has a workers' comp component, a lot of times they will reach out to me. I just resolved one within the last couple of months where an attorney in Louisville was handling the negligence part of the claim. It was a truck driver who was injured in a trucking wreck, and he handled the negligence part and asked me to handle the workers' comp side of that because he does not handle workers' compensation claims. And I've had workers' comp attorneys who don't handle negligence claims that are friends of mine, and even though they know I handle workers' comp as well, and negligence cases, they've referred to the negligence part of the claim to me while they handled the workers' compensation claim. So you can have two attorneys, one handling one part, one handling the other part. Myself, pretty much always will handle both claims because I do workers' compensation and general negligence claims as well.
Well, in depending on the facts of the matter here, the situation, there may also be a Social Security disability claim involved, and you could handle that as well were it to happen. Correct?
Correct. Yes,
Okay.
and
Wow.
and that's happened a few times
Yeah.
from that standpoint where we've had three different types of claims going for the individual at one time.
Wow.
Yeah.
But the good news is you know the case. I mean, because you're in it, you're just dealing with three different systems, I guess, at that point.
Correct. I'm familiar with all three of the systems. My staff is familiar with all three of the systems. I've got two paralegals that work for me, and they've been with me for years and years, and so they're familiar with all of those systems as well. From that standpoint, and to some extent, I think it's more cost effective to have one attorney handling all of the different claims that you have. If you can do that, when I'm working with another attorney on these claims, we share information back and forth without it costing us from that standpoint. So if I get medical records, I'll share it with whoever the other attorney handling the negligence or the workers' comp component, as the case may be. From there, so they don't incur that additional cost of obtaining the same medical records again, but there still can be other costs associated with pursuing these claims, whereas one attorney can kind of absorb all of those costs and you don't get charged multiple times for the same thing.
Well, and I think either in previous episodes or definitely on some of the information on your website, the workers' comp process and the Social Security disability process don't really work quickly. But at least if you were handling all three, you could kind of expedite that because you're not waiting on other people to get back to you. It's all in-house at that point. So there may be, again, another advantage, if you will.
There is an advantage from that standpoint. Obviously, whenever I'm representing a client, I try to resolve the claims as quickly as possible, regardless of what type of claim it is. Now, certain things have to occur before you resolve a claim. I have people come in to see me, and they will ask me, "How long is this going to take?" And depending on where they're at in treatment, but usually my first answer to that question, especially if they're still getting treatment, is that depends on how long it takes you to reach maximum improvement from this injury, because I'm not going to talk to you about settlement of your claim until I know what your permanent problems from this are. I hope there's no attorneys out there settling cases before their clients reach maximum improvement. But a lot of people want to get the claim resolved very, very quickly, and you can do that, but you're not going to get fair value for a claim if you do that, as a general rule. But also, if I'm handling all of the cases, I may know that I can push once a person reaches maximum medical improvement, I can push the workers' comp claim and get that one resolved quicker than I'm going to get the third party case resolved, or quicker than I'm going to get the Social Security case resolved, or it may be that I can get the Social Security case resolved quicker. So I know which one that I need to push the fastest, because it's going to resolve the quickest to be able to take care of my client's financial situation and take care of their medical bills as well. And then that puts them in a situation where they can wait the time that's needed to resolve the other claims in a more favorable light for them.
Well, in previous episodes, we've talked about the fact that with workers' comp, assuming this is a workers' comp claim that you're filing, obviously they get the TTD benefits along the way. It's not like they're waiting. I mean, the workers' comp kind of steps in fairly quickly and begins with that process of getting some checks out to you.
Correct.
Which is a buffer. But you're talking about resolving the overall case.
Resolving the overall case. Yeah. And yes, with workers' comp, as long as the employer and the insurance company has accepted the claim, and as a general rule, they do. There's some that are more questionable, but most of the time, especially in construction fields, because if somebody's on a scaffold that gets knocked over, or on a scissor lift that gets knocked over, pretty obvious that's a work-related injury there.
Right.
And so you're not going to have the fight over whether it's work-related as much as if someone lifts a box and has back pain, and they may have had back pain a year or 2 years before, and then you may fight a battle over whether that is or is not a work-related injury there. But if the carrier accepts the claim as being work-related, if the person is off work, then they receive the temporary total disability benefits, which is basically what's paid to compensate for the lost income that you're receiving during the time that you're actively getting medical treatment and out of work because of that.
Well, you'd mentioned scissor lifts and scaffolding accidents, and interestingly enough, there's another system that could actually come into play, and that's OSHA.
Correct.
And so oftentimes in a construction case, you may have to understand what's going on with OSHA and understanding, what those regulations are and how to manage that particular aspect of the case has got to be valuable to your client.
It is, especially in both the negligence and the workers' comp perspective. Those knowing OSHA regulations, knowing whether there's been a safety violation of some sort, can be very valuable to the client in that regard. If that certainly could form a basis for the negligence claim if there's an OSHA standard that the subcontractor violated that caused an injury, then that essentially establishes negligence on the subcontractor's part if the employer fails to provide follow OSHA, doesn't provide their proper protective equipment, or some other violation of OSHA, then the workers' comp benefits can be increased for that injured worker in that setting. So being familiar with OSHA, being familiar with the proper experts to look at this accident scene, to look at the facts of how the accident occurred, can be beneficial on both the third-party claim and on the in the workers' compensation claim.
So again, if it's determined that there's an OSHA violation involved, again, that's a financial advantage to the injured party, or can be a financial advantage, but you've got to know to look for that.
Correct. Exactly. It can be. And in fact, in a workers' comp claim, if there has been a safety violation by the employer, whether it be an OSHA violation or an internal safety policy of the employers themselves, it can result in a 30% increase in the income benefits to the injured worker, not only the permanent income benefits, but the temporary total disability benefits can be increased by 30% as well from that standing.
I mean, that's significant. I mean,
yes.
That's a significant bump.
Yes, it is a significant bump. And I've had cases where that 30% actually equaled greater than $250, $300 in a case.
Yeah.
So it can make per week for the individual, and that makes a big difference. If you've got somebody who's a high wage earner, because workers' comp benefits are capped, so if you've got someone who's making a lot of money and then they're capped, normally temporary total is paid at 66 2/3, but with a high wage earner, that what the cap is on their benefits can be such that they're actually getting 50% of what their normal bring home wages were, and so being able to get that extra 30% increase can frankly make a difference between the individual being able to pay their bills or getting behind on paying bills.
Right, especially when they're limited in their work capabilities now because they're trying to heal.
Exactly.
So again, anything
Yes.
you can do in that regard. Now, obviously, down in this part of the state, we do have a lot of temporary workers, a lot of seasonal workers who come up, whether that's roofing or building trades and things like that, or agricultural trades even. If let's say I don't live here, I'm up here on a visa or maybe even not even documented, do I still have the rights and the protections under workers' comp if I were injured on the job?
Yes. Yeah, if you are working in Kentucky in an employment covered by workers' comp, then, and I say that because there are some employments it's not. Generally, the agriculture field is one of them that's not covered by workers' compensation. But if they have migrant workers, then federal law requires them to have workers' comp. So actually, they are covered by workers' comp then because they are because of the federal law requiring that. But in the construction field, you have a lot of workers coming up to work in the construction field or even some factories And it doesn't matter where your home base is or where you grew up, what state you live in, what country you live in. If you're injured in Kentucky on the job, you're entitled to workers' compensation benefits, and it's the same regard. I mean, you're going to be entitled to the exact same as a Kentucky citizen would be entitled to if they had the exact same injury that you did.
Well, and in fact, you've represented a number of these individuals who don't actually live here full time. In fact, I think you said these individuals happen to live specifically in Mexico, and they're still receiving comp benefits.
Yes, there's been some migrant workers up here, farm workers that were up here that specifically that I've represented in the past I've represented several, but two that stand out that had really, really significant injuries and were not able to go back and do any type of physical type of labor activities because of that, and that's all they'd ever known their whole life. They didn't have even a sixth grade education, if I recall correctly, and the benefits. We were able to resolve the claim. They're back in Mexico now. Actually, I think both of them went back even before their contract time because they couldn't fulfill the contract because they couldn't work anymore. But we were able to get the benefits set up, sent to Mexico. In fact, I believe on both of those we convinced the insurance company to do direct deposit so that they didn't have to worry about a check being sent international to Mexico. And the biggest problem we had really in those cases was finding medical treatment in Mexico for the individual.
I believe you said you had one individual who lived fairly north and decided to come back to the United States periodically, and you were able to find a physician down there, and somehow the system arranged for treatment for that individual.
Exactly. The person, their home in Mexico was not far across the border, and when we were looking for a doctor, they actually preferred to come back into the United States for the treatment. I can't remember if they were in Texas or New Mexico, where they lived across the border, but they preferred to come back across. And that made it a little bit easier, frankly, because the workers' comp carrier was much more comfortable paying a doctor that was on the U.S. side of the border than the other side, and getting the medical records and things of that was easier for the workers' comp insurance carrier. But even the one that lived in the interior, it took a little longer, but we were able to work out to where they could have the lifetime medical treatment that they were going to need and were entitled to under the law. So,
well, and interestingly, they didn't have to come back to Kentucky for treatment. They were able to treat at a location fairly convenient for them.
Yes, and that occurs frequently in my practice. I represent. One that stands out is truck drivers. I represent truck drivers all over. I've represented truck drivers in New Jersey, in Texas, in Arizona, in Colorado, all over the country that were injured in Kentucky, so they had a Kentucky workers' compensation claim, but we've always been able to find doctors close to where they live so they could get their medical treatment there instead of having to come to Kentucky.
Which just kind of makes it a lot easier for them, obviously, and their families.
Yes.
Okay. Well, let's transition back in discussing, I guess, construction accidents. There's a lot of common injuries that you would normally see that would qualify for these types of benefits. Obviously, it starts out with the ones that are a little bit less severe, I guess, if you looked at the spectrum, which would be like strains and tears. But then it gets a lot more serious.
Yes, it does. Lifting up heavy 2x4s, long 2x4s, 2x10s, 2x12s, can cause a strain of a muscle that can be a temporary injury, and hopefully is only a temporary injury in that setting. But then when you're walking around construction sites, you've got all kinds of tripping hazards where people can trip and break a bone or
twist a knee or roll an ankle.
Exactly, twist a knee and have to have knee surgery or something of that nature. And we've already talked about people who are up high, either scissor lifts or on scaffolding, or roofers on a roof setting and have a fall for whatever reason, or the scissor lift get knocked over, and then the injuries obviously are getting much more severe in that setting. You have equipment, multiple types of equipment on a construction site a lot of times, and they can crash into each other if people aren't paying attention to what they are doing. The road setting, like I mentioned before, and unfortunately, I have represented people who were on a road crew and somebody wasn't paying attention to the flagger and then hit somebody that was there working, and so you've got all of those types of injuries. And even in construction, you're dealing with not just hammers and nails and things of that nature, but you've got welding, you've got concrete workers, and you've got electric. And unfortunately, there's been times also that when people were working with electricity, or either working on equipment and or the electric for a building or something of that nature, that they accidentally get electrocuted or get an electrical shock that can have very drastic consequences, obviously leading to death if it's severe enough. But even the ones that aren't that severe can have long-term consequences to someone when you have a certain amount of voltage and all going through your body.
Right, and if it's a lockout tagout error, or violation, that may come back over to the OSHA area again.
Correct.
Which allows them to. But I mean, maybe somebody's walking past a panel and sees an extension cord came unplugged, so they just plug it back in, but they don't realize somebody at the other end is working on a piece of machinery that just starts up.
Right.
And so there's all sorts of things. I mean, it's complicated. There's usually a lot of factors on a job site anyway.
Yes.
And it's just unless there's really good communication out there. When you talk about the falls and issues off of a scaffold or something that goes on with a scissor lift, or falling off a roof even, neck and back injuries are significant. For a lot of different reasons that may result in paralysis. But it could also result in a lot of other issues that are going to require a number of different surgeries. So again, having the workers' comp claim available to you, having the temporary total disability, the TTD payments coming in so they can kind of pay some of those bills along the way. And then again, having somebody like you with your experience trying to figure out, well, what was the actual root cause? Is there another action here, such as a third-party claim, to come in? I mean, you're looking at all these factors from day one.
Yes, one of the first, when I'm first talking to a client, one of the things, excuse me, one of the things that I am looking at is, in trying to determine in my own mind, is what are their various types of claims there. Do they have a workers' compensation claim? Do they have a third-party claim against someone else for negligence? Is there a potential Social Security claim here? And, unfortunately, sometimes, the person's medical treatment, there was something messed up on the medical treatment, so there might be a medical negligence type of claim there as well. So when I first sat down and talked with the individual, and ongoing throughout the entire representation, because as you go through a claim and go and gather more information, then you may see claims that you didn't, that the claimant that come in, the client that come in to see me the first time may not have known that the person who violated the lockout tagout and turned the equipment back on that they were working on was a subcontractor or something. So then we may develop a third-party claim later on that we didn't know we actually had to start with. So that's an ongoing process as you represent someone, is to make sure you're advising them of all of the different claims that they have in pursuing all the claims that they want to pursue.
Right. So as we look at this, if I'm on the job site and I'm injured, can you kind of walk me through the process? I mean, what should I be doing, or what should my family be doing on my behalf? How do we get all this started?
First thing to do when you're injured on the job is to notify your superior. It may be a supervisor, it may be the line lead, or superintendent on the job, depending on what type of industry and what type of job site you have. But in Kentucky, you're supposed to give notice of a work-related injury as soon as practicable after the work injury occurs. And that can obviously be different depending on the exact situation.
It's a little gray area there. You don't have to immediately go right to your supervisor.
Yes.
Hey, I just got knocked out. If you're in the hospital, eventually you're going to have to notify them.
Exactly. You've got to notify them as soon as practical. And I've had clients come in and say, well, I got hurt on the job, but I didn't tell them about it until 3 days later, and they said since I didn't notify within 24 hours, I can't pursue a claim. That's not the law in Kentucky.
Right, and that's I wanted to circle back around that.
Yeah.
Company policy really doesn't matter at this point. This is Kentucky law.
Exactly. Company policy, they may have their policy, but they don't set Kentucky law by their policy from there. So, I've been successful in having notice that was months after the fact be considered a timely notice because the person thought they just had a minor, they did an activity they weren't used to doing. They had sore muscles. They thought it's just sore muscles from doing a little heavier lifting than they normally did, and then found out it was something more severe, and then notified the employer when they found out it wasn't going to go away. But the best thing to do is to notify your supervisor, superior, as soon as you can notify them. The second thing to do is to seek medical treatment. A lot of times, a worker thinks, well, I'll see how it's going to go before I seek medical treatments. If I'm better tomorrow or better next week, and if it's just a sore muscle, that's probably okay. But if you're having, if you've had a back pop and pain now going down your leg, and you've never had that before, then you probably need to go ahead and get that seen about sooner rather than later. There, obviously, if you've got a broken bone, that pain's going to be such that you got to go seek medical treatment. But I see a lot of people try to tough it out, and I understand that. Frankly, that's kind of the makeup of my psyche as well. Is I'm going to try to tough it out, and I don't need to go see somebody. But that's a lot of times you're doing yourself a disservice by doing that. So if you're having problems and you think you need to seek medical treatment, seek the medical treatment. Go to the emergency room. Go to your family doctor.
Even the urgent care, you just walk in and see somebody.
Yes,
and that's for two different reasons. I mean, the longer you wait to seek treatment, it gives the other side or the company side a chance to say, well, that really didn't happen here. You did something on the weekend or you did something at home. So it gives them some wiggle room, which may be unfortunate. But at the same time, it also starts that medical record, and you want to tell them, hey, I got hurt at work. So there is something in the record that says, okay, this is why they came in.
Yes, and that is absolutely true on both counts. The longer you wait to seek medical treatment, the much more likely the insurance company is going to deny that your claim is work-related. And then if you're off work, you're not going to have the temporary total disability benefits voluntarily paid. Now, we eventually may recover those if we're successful, but having it while you're off work is a whole lot better than getting it 6 months down the road.
After you've had to fight for it and everything else. Yeah.
Exactly. So getting that medical documentation will help to convince the insurance company, yes, accept this claim. This is a legitimate claim. We need to go ahead and start paying these benefits. From that standpoint, and the other side that you mentioned is to tell the medical provider what happened, how the injury occurred, that you were at work, you lifted a box, or you tripped over whatever it was, or whatever the injury caused the injury. Let them know how the injury occurred, because that can make a difference on the diagnosis. For instance, if you lift something and have pain in your knee, then the doctor's going to look for something different than if you stop abruptly and pivot and turn and injure your knee. So if you just go in and say, I injured my knee at work, they're probably going to ask you a little more detail about it, what occurred, so that they can help try to determine exactly what you did to the knee right off the bat, or at least go in the right direction from that standpoint. But it also documents that, yes, this occurred at work. And and I see unfortunately frequently where people come in to see me, and they sought medical treatment 2 or 3 days after the injury occurred, and they didn't mention the injury. And those cases are really, really difficult.
You're not doing yourself a favor.
You're not doing yourself a favor, and you're going to be a lot harder to find somebody that's willing to fight for you, because the medical documentation may not be there in those settings, and so you could be left holding the bag for all the medical treatment and not have any wage losses, benefits coming in when you're off work if you go that route. And the same if you're filling out paperwork. A lot of times when you see a doctor, they'll have you fill out the forms. Make sure you write on there that it occurred at work. As
Hurt on the job or
yeah,
at work
hurt on
or
the
something.
job, lifting something at work, tripped at work, whatever it is. But make sure you document that it occurred there at work. And then if you do that, and I've used that to go back and then rebut what the doctor's note says and said, no, this is what they filled out in the client's handwriting. This occurred at work. They didn't say that it just spontaneously occurred. The doctor just didn't get it correctly in their office notes. And doctors are like everybody else. They make mistakes in transcription at times. And so those, that can be very helpful in establishing that, yes, this is, if the doctor doesn't have the things exactly correct in their office note.
Well, and that's the interesting thing about these cases is so much of it comes down to the medical records and what's in the medical records and what's the doctor willing to say when questioned about it. So again, being as thorough as you can. I know you're trying to get some relief. You're trying to get through the system, maybe get on home, but take some time on this documentation. It's important.
Right, exactly. And then after you've gotten the medical treatment and are moving forward with the medical treatment, then is the time to reach out either. And if you're in the hospital and because of an injury, have a family member reach out. But that's the time to reach out to an attorney to find out what you're entitled to under workers' compensation law or any other law that may apply to your situation, whether there's a third-party negligence claim or something of that nature. Reaching out to the attorney, then getting that information, and a lot of times I'll have people reach out at that point, and I will explain to them what they're entitled to, and depending on how things are going with them, I may say, well, let's let the insurance company have the opportunity to do what they should do before I get involved. And it may be one that we know the insurance companies are already, there's certain insurance companies, I know how they treat people going in. And if I know that's the insurance company involved, I know you need to go ahead and get an attorney now because they're not going to treat you fairly. And some insurance companies do treat people fairly. So the attorney should be able to give you, if they got experience anyway, in handling your type of claim, they probably have a decent idea on whether you will or will not be treated fairly and when you need to get the attorney involved.
Well, I think you spent your entire career here in Western Kentucky, so you also have a good idea with how the other employers may be handling the case as well and how responsible they'll be or how receptive they'll be to working with the injured employee.
Yes, and I've never truly understood when employers get upset over an injured worker seeking medical treatment or an injured worker obtaining an attorney and getting legal advice. And I'm not going to get anybody in a workers' compensation claim or any other type of claim. I'm not going to get anyone more than what the law allows them to have. I'm getting you what you're entitled to receive is what me or any other attorney is obtaining for you in a workers' compensation claim. From there, and the employer, and I've seen employers retaliate against injured workers over pursuing a workers' compensation claim or even seeking medical treatment for a work-related injury because they don't want a quote-unquote lost time injury because they think it's going to affect the rates and all of these things. And I've never really quite understood that. There's a lot of employers, and most employers out there, frankly, that I've dealt with, they want their injured workers to get the best medical treatment possible, get better, get back to work. And, that I understand. I'm an employer as well. If I have an employee here that gets hurt, I want them to get treated. I want them to be treated well by the insurance company that I'm paying money to make sure they're treated well. And then I want them to be back at work as quick as they can be back at work safely without problems for them. And, the employers that don't want that, it's, unfortunately we see frequently some employers that treat people like a piece of equipment. And, I have trouble understanding that mindset, but unfortunately that's what happens at times. And having done this for more than 27 years now, I know which one of those employers are, which employers are that way. And can tailor how I represent someone to lessen that impact at least as much as I can. Can't get rid of it completely, but I can at least lessen it to some extent.
Well, Jeff, you brought up a really interesting point here, and I want to let's close out with two final questions. One, talk a little bit about what happens if an employer does retaliate against an injured employer or injured employee, and that could be just changing their job, changing their maybe you're not getting the right shift or stuff like that. But let's talk about that because that's a major concern. I don't know if I even want to file this claim because I'm worried about what will happen. And then let's talk about how much it actually costs to hire you. Yeah. Because that's a different game altogether as well.
And as far as what can be done or what happens when an employer retaliates, it kind of depends on how they retaliate. If a person is on a weight limit, for instance, they can
light duty type,
a light duty type thing, so they cannot go back to doing their normal job duties. They can bring the employee back into work in basically a make work position, and I've seen them do that in situations, and even in certain situations, even potentially reduce their rate or put them on a different shift. And there's not really a whole lot that can be done in that setting as far as a claim against the employer for retaliation. Now, an employer that does something because the employee pursued a workers' compensation claim because they got injured on the job, if they say, look, you lifted this box and herniated a disc in your back, you've caused our workers' comp premiums to go up, so you're fired. That you can sue the employer for that. That type of retaliation is against the law of Kentucky, and you've got a claim against that employer for doing that. If they say you hired an attorney to pursue your claim and we don't like that, so therefore we're not going to bring you back to work, and your employment is terminated, or because of that we're going to even though you're released to do regular duty, we're going to have you go scrub toilets in the factory instead of going back out on the machine and retaliate because you hired an attorney. That would pursue a claim against you'd have another claim against the employer you could pursue in that setting. And both of those types of things and even the others are things that I can deal with. A lot of times I can reverse those actions. When I point out to the employer, you're not allowed to do that, and you human resources manager who did that, when we sue your company for this retaliation, your parent company may not like what you did when they got to pay more money than what they would have had to pay to start with, and get that action reversed for the injured worker and get them back to work. And get their job back and get them not being mistreated by the employer in that setting. So there's things attorneys can do to prevent that.
Well, it puts them on notice. Somebody's watching.
Exactly. And then the other side is the way I work on a workers' compensation claim or a third-party negligence action or a Social Security case, even for that matter, is all on a contingency fee basis. So my fee is contingent upon what I recover from my client. And so when they come in to see me and hire me, they're not out a penny. The only time I ever receive a fee on these type of claims is at the end of the case when I put money in my client's pocket. That's when I get paid my attorney fee and I also advance all the litigation expenses.
Well, those are commonly referred to as case costs and expenses.
Exactly. Case costs. When I write to doctors to get records, they charge me. When I hire expert witnesses, I pay for that expert witness.
You travel to take a deposition somewhere.
Exactly. And all of those costs, I advance all of those costs. Those are contingent upon recovery as well, at least with me. Some attorneys don't make those contingent. I do. So if I am successful, I get paid in my attorney fee and I get reimbursed my expenses. If I'm not successful, the client doesn't owe me a penny for anything in that setting. So I get paid at the end the same time my client gets paid their permanent disability benefits. Now, my workers' comp clients get benefits, the temporary total disability benefits as they're off work from that standpoint. But when the permanent claim is resolved, that's when I get paid.
And so, again, there's not an hourly bill. There's not an hourly rate they need to worry about. This is a contingency fee. It's based on you've got to go win the case, and then that's how you earn your living.
Exactly. That's exactly it. There are some cases, some types of claims I do handle on an hourly rate basis, but the initial workers' compensation claim for income benefits and permanent disability benefits, negligence claims, Social Security cases are not hourly rate cases.
Well, Jeff, I really want to thank you for your time here. I know that this is a big area of your practice in terms of not just workers' comp, but also construction accidents. I mean, these happen all the time. And, it's a dangerous environment when somebody has that as a job. When they're in the trades like that, it's dangerous.
Yes.
And people need to be protected. They have rights, and they have systems out there ready to back them up when they need it. But they need to pick up the phone and engage with you.
Yeah.
And again, I appreciate it. Friends, if you're visiting Jeff's website when you listen to this particular episode, I will have in the show notes below the link to this episode you're listening to. I'll have links to various pages and references on his website to give you a little bit more information about some of these topics you may have heard. And I hope you'll reach out and contact Jeff. So, Jeff, once again, I appreciate it. I know you're a busy guy. And friends, we'll be back in about 2 weeks. Thanks so much.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.